Hello, you're listening to the Terralex podcast, where we break down current issues and trends in the legal industry. Join us as we gain valuable insights from our member law firms across the world, as well as from the in-house counsel community and experienced professionals in their field.
Good afternoon, everyone, and thank you for joining us for this seminar. We have a top 10 of things to know about the current state of Brexit. And if Nicole, you could move the slides on, we'll begin with our first top 10. So, question one, Brexit occurred on the 31st of January 2020. What has actually changed? And I'm going to take the answer to this question. So from 11 o'clock UK time last Friday, the UK has ceased to be a member of the European Union. So the Union flag has come down in Brussels and we have been taken off the EU institutions' websites. The United Kingdom's judges have been sent home from the Court of Justice and our members of the European Parliament have lost their jobs. The UK no longer has a formal role in policy or lawmaking for the EU, and the EU has now opened its delegation to the United Kingdom in London on the 1st of February. So Brexit has been politically significant, but for most people and businesses in the UK, they won't notice much of a practical change because under the withdrawal agreement with the EU, we have now entered into a transition period which is scheduled to last until the 31st of December this year. The effect of that is that for most practical purposes, the UK will behave as though it is still a member state and the EU will treat us as though we are still a member of the EU. Free movement of people, goods and services is preserved, but there are some changes at a high and detail level that are worth noting. At a high level, the UK will not automatically inherit the benefit of the external treaties and agreements that the EU has with third countries. And so there are processes in place to protect or to try to protect the UK's involvement in those third country treaties until the end of the transition period. And there are also moves afoot by the UK to enter into bilateral arrangements with all of those third countries on a successor basis at the end of the transition period. At a micro level, one thing for people to think about is the status of people. If you are an EU national living in the UK or a UK national living in the European Union, then you will be protected in terms of your rights to remain so long as your residence is established by the end of the transition period. So the next 11 months will be quite important for free movement of people. And so I have taken us until the end of 2020, and we're now crystal ball gazing about what Brexit will mean after the 31st of December this year. And there is a short answer to this question, which is truthfully, we do not know. And the longer answer is that it will depend very much on what happens in the course of this year in terms of the negotiations between the UK and the European Union. Now, as I've already said, some parts of the future relationship are already agreed. So, for example, the rights of individuals who are already resident in the UK or in an EU member state before the end of this year, they will be protected. And equally, we also know what is to happen about the movement of goods and trade on the island of Ireland and how that is to be managed. And I'm going to come back and talk about that in a little bit more detail. But beyond those important but discrete areas which have been dealt with in the withdrawal agreement, we don't know very much more about what will come to be the future trade and other relationship between the UK and the EU. We're about to embark on a period of negotiation, and on Monday of this week, both the EU and the United Kingdom published negotiating positions in rather greater detail by the EU than by the United Kingdom, but that's not surprising given that the EU Commission was asking the Council, the European Council, to authorise it to enter into negotiations on behalf of the whole of the EU. And the three key headings that the Commission has identified as part of the negotiating mandate are around general arrangements on values and principles and how the new arrangement is to be governed. Second, economic arrangements, including provisions on trade and a very heavy emphasis on level playing field guarantees. And thirdly, security arrangements between the United Kingdom and the rest of the EU, including cooperation in criminal matters and on foreign policy, security and defence. By contrast, the UK's position, as stated at this stage of the negotiations, is that it will be seeking maximum flexibility to allow the UK to carry on with trade negotiations with other third countries and enter into free trade agreements with, amongst others, the United States of America. Two more things to say about the coming period up to the end of the year. The first is that it is at least possible that the transition period might be extended. That's allowed for in the withdrawal agreement. The UK Prime Minister, Mr Johnson, has said he will not extend the transition period. That remains to be seen whether that continues to be his position. And secondly, 31st December 2020 is a key date for the legal changes that will happen in United Kingdom law, where we move from being regulated by EU law to bringing European Union law into our domestic system and starting to diverge from European rules. So that's a little bit about what Brexit might mean after the 31st of December this year. Will all parts of the UK be affected in the same way by Brexit? And I'm sorry that you're having to hear from me a third time, but just a reminder to our whole audience of the different legal jurisdictions that exist within the United Kingdom, and of course the different legislative arrangements that exist within the United Kingdom with parliaments and assemblies at a UK level and also at a Scottish, Wales and Northern Ireland level. So there is some potential for legal divergence within the United Kingdom after Brexit, and that's because some of the areas that were formerly regulated by EU law, like environmental protection and agricultural law, will fall to the individual regional parliaments to make decisions about. There are limits on how far they can go, and the UK government has taken steps to preserve a consistent internal market within the UK, but there might be some legal divergence, and there may be the potential for political divergence. So some of you listening will be aware, for example, that different parts of the United Kingdom voted differently in relation to Brexit, and the current Scottish government has used Scotland's resistance to Brexit as a mechanism for campaigning again for independence. One of the key differences for the UK relationship with the EU is in relation to Northern Ireland. And again, many of you will have heard of the Northern Ireland backstop, and that has been removed, and we have instead a Northern Ireland protocol. The Northern Ireland protocol seeks to achieve something which looks to be very challenging indeed. It seeks to achieve a situation in which Northern Ireland forms part of the United Kingdom customs territory, but forms part of the European Union single market for trade in goods. That leads to some pretty complicated provisions about how tariffs will operate as between different parts of Ireland and as between Northern Ireland and the rest of the United Kingdom. And I would be delighted to take questions about that very complicated arrangement at the end of the seminar. Shall we move on?
So what you've heard from Christine is, and as you'll probably have gathered from that, is it's a very political issue, Brexit, in terms of how things work. But what they're doing with these negotiations are going to have some very practical implications. particularly for businesses and people looking to do business either in or with the United Kingdom. And the first thing that I wanted to sort of focus on was, if you are looking to invest in the United Kingdom, what impact could Brexit have on that? So you're purchasing a business in the UK, will Brexit affect this? Now, the interesting thing about Brexit is that despite the sort of uncertainty and the political turmoil, that certainly has not stopped investment coming into the UK. And some industries, I think we found, have been stronger than others, and particularly if you look at, for example, the UK's tech sector. Actually, investment in the UK, interestingly, in 2019 was outstripping both the US and China. And examples of the UK, so having developed sort of 8 unicorns in the past year, more than anywhere else in Europe, sort of suggests that tech, despite Brexit, is alive and well. There's also a lot of industries in the UK that won't directly be affected by Brexit. There are certain types of service industries that will be less affected. There are businesses that have a more sort of global rather than specific European outlook are likely to be less affected. And one of the interesting conversations I was having was about with a technology company that said, look, Brexit's all very interesting and we design and we develop the tech sort of here, but actually we manufacture out of the Far East. So there will be some implications for that, but it may not be as dramatic as may impact sort of other industries. When it comes to investment, actually the biggest thing that's impacting from Brexit has been currency volatility. The pound sort of fell off a cliff after the vote. What's been interesting for the UK, and I think what's driving the investment, is that actually a lot of UK businesses look cheap relatively as a result of the fall in the value of the pound. So someone looking to invest needs to think about how currency movements might affect their investment. If you're doing a deal, you would think about potentially currency hedging, depending on the point at which you might sign and then complete. And I think things like material adverse change clauses have become a lot more interesting for potential acquisitions where you may not have seen them historically. Certainly that's something that would be sensible to do. In terms of going forward, if you are investing in a business in the UK, you're going to find things may change regulatory-wise. So one example would be merger filings. You're likely to need a separate UK approval, even if you're doing an EU merger filing. So going forward, you will file sort of your merger filing controls into the EU, but you'll also need in parallel to file in the UK. And you'll see this theme coming throughout, which is there's going to be a lot of double track sort of processes required, much as if you're going to have to file in the US and file in Europe. Now you have to file in the US, file in Europe, file in the UK, for example. Other things that will be interesting to come up about are going to be the European cross-border merger regime is not going to apply any longer, so it may make sort of doing mergers between UK and European companies a little more complicated. We go back to what I would describe as the old-fashioned way of doing it rather than having a sort of nice legislative mechanic. There might be interesting questions around the UK government's approach to state aid and whether the UK government's more willing to be a, quotes, investment partner, but of course, a lot of that will depend on the outcomes of the negotiations with this EU and this concept of a level playing field. And one of the things I think we're going to see is whether there's this divergence in regulation providing opportunities. Again, one of the questions that come up is, would we see regulatory alignment moving closer to the US? And this is a big debate going on at the moment where I think the EU's expectation is the UK would stay aligned. I think the UK government has an eye on both trying to do a deal with the EU, but an eye on the prize in the sense that they do want to get closer to the US, possibly the rest of the world, Africa, Asia, and where are the opportunities in Brexit to do that. So what we might see is, for example, people wanting to launch in the UK because there's more of a closer regulatory alignment than perhaps historically if there was a divergence from the EU. But I mean, one of the themes throughout this is there's a lot of speculation as to what might happen. Areas that I think might get interesting as we go forward. Healthcare. The Prime Minister, Boris Johnson, has said the NHS is not for sale, but I think we're probably going to expect to see an interest in more activity with the NHS, which could be interesting to US health companies. I think technology is going to be big. And of course, there's been a big debate about infrastructure and the use of 5G and who would be the 5G suppliers, particularly Huawei and the issues around the Chinese government. If you are doing a deal in the UK, I think the key, as always, is due diligence. You need to be wary of businesses reliant on sort of mobile EU-based workforces, seasonal workforces, and how you're going to address that. Businesses that have a sort of homogenized product offering with a significant export to an EU customer base, or businesses which are highly regulated under EU regulations. And all of these things you're going to have a real think about, I think, how that might impact the sort of future prospects going forward. So one of the questions I often get asked is, and historically I think the UK has been seen as a sort of gateway to Europe. So if I'm a US company wanting to sort of move out of the US market into Europe, where's my foothold? The UK is a great place to start. It's a common language. There's a common sort of legal system in the sense that it's based on common law, even though different regulations. And therefore, will this continue? I think the main concern about the UK being a gateway into Europe comes around the impact of tariffs. The expectation is if we don't do a free trade deal, then there will be tariff barriers put up between the UK and the EU, and that will impact on supply chains, the ability to move products easily across border, the bureaucracy that goes with it. And it's a question more, I think, of sort of how you might do this. From a personal perspective, I think the UK is still going to be an attractive place as a sort of starting point if you're expanding outside your home territory, all for these historic reasons, and not least because the UK remains a market of 60 million plus people just in itself, even without thinking about going into Europe. What you will, however, need to think about is your sort of UK/European distribution model. So things like, can I set up a model that minimizes the number of times my goods cross the border? If I'm sourcing even from outside the EU, where should my procurement hub be located for supplying EU jurisdictions? And quite likely, a European based procurement hub is likely to be more attractive. You may need to look at things like free port arrangements, use of bonded warehouses, and that in your distribution supply chain. And that's a different dynamic than I think has historically been the case. That said, you're probably going to see changes in tax, which may make the UK a more attractive place. And again, this level playing field concept, I think, is really key when it comes to negotiations. One of the things the EU has been very clear about is they don't want to see a sort of Singapore on the Thames, effectively the UK being a sort of low tax, low regulated jurisdiction right on their doorstep. And they very much distinguish that from perhaps like deals they've done with Canada or further afield, saying, well, we're less bothered about some of these issues because actually geographically, these competitors, these countries are further away from us. Personally, I think the UK is still going to be a friendly place to act as a gateway. It's familiar, it's got certainty of law, it's got talent, it's likely to be sort of friendly from a regulatory perspective. And the fundamental factor is even when the UK was a gateway into Europe, Europe is not a one-size-fits-all continent. You can't, although there are European regulations, there's a lot of domestic regulations still, there's a lot of different languages to deal with, and there's still a lot of nuances that go with that. So it's certainly not the way we'd have done it historically, but I think there will be a future as the UK as an excellent starting point still for launching a sort of international expansion program.
And one of the things, Paul, I don't know if you agree, is that there's been a rather odd move by what would be thought of as a conservative government towards greater state support for industry. And it may be that freed from state aid constraints or the same European state aid constraints, that the UK becomes more attractive for state support to industry. I don't know if that's a view you'd share.
No, absolutely. And I think this is going to be an interesting tightrope that the UK government's going to have to walk, particularly in these negotiations, because of the EU being fearful of this sort of rebellious country right on its doorstep with a strong economy. It's going to want much more alignment. Whereas I think if you look at this very theoretically, what is the point of Brexit if you simply stay aligned to the EU and you're sort of an EU member in everything but name effectively? And so I think there's going to be a lot of pressure on the government to look at areas of divergence. And I absolutely agree with you that sort of supporting through the state may well be something of interest. And this could make it a sort of help with the risk profile of investments in the UK. If you think, well, I've got a UK government behind it, it's not dissimilar to some of the things you've seen Switzerland try and do historically, I think, with sort of tax advantages and encouraging companies to base themselves. Although interestingly, I think with Switzerland, we've seen the EU try to sort of get them to fall into line and not be that, because even more so on the doorstep, Switzerland right in the central of Europe, they don't want a sort of differing approach.
And so it's back to me on the question about how Brexit will affect your ability to send people to work in the United Kingdom. And I think this all depends on who the you is in the question. So again, it will be familiar to the audience that control over immigration, control over migration to the UK, particularly by EU national workers, was a major political factor in the referendum campaign. And so the current United Kingdom government has been clear that one of the outcomes of Brexit must be the ability of the United Kingdom to set its own rules and standards for immigration and for workers coming to the UK. And that can be of advantage to some countries who up until now have not enjoyed the same treatment as EU nationals have, and obviously of some disadvantage to EU nationals. The people who are not going to be affected by Brexit are Irish nationals. So if you have an Irish passport and you want to work in the UK, then the common travel area between the United Kingdom and Ireland will remain, and there will be effectively free movement between Ireland and the rest of the United Kingdom, or the United Kingdom, for workers who want to work between the two. I've mentioned that for EU nationals already in the UK by the end of the transition period, their rights to remain, and indeed the rights of family members, will be protected. But after the end of the transition, as we move into Brexit proper, we are going to see a new immigration regime for the UK. We're going to see an extension of the existing points-based system, which applies to non-EU nationals coming to work in the United Kingdom. And we're going to see that points-based system expanded to include medium-skilled and potentially unskilled workers. Again, the audience may be aware that up until now, we've not had a points-based system for unskilled workers because of the ability of EU nationals to move freely in and out of the United Kingdom. So we're going to see a much more structured regime at each level for migration, and that may be helpful to those of you who want to send non-EU national workers into the UK. It's going to be difficult politically, and there are still going to be controversial questions to be answered. There has been, over the last few days, quite a lot of debate about the appropriate salary level, the threshold at which you must be earning, or the job must pay as a salary before you will be able to use a non-UK worker and get a visa for a non-UK worker to come into the United Kingdom to deliver that role. And it's also relatively controversial within the United Kingdom because it's another area where the Scottish Government has been campaigning for a different system to apply in Scotland. That's not least because the Scottish economy relies very heavily on rural and farming workers, many of whom would have fallen into that lower skilled category under the EU rules. And odd as it might seem to think about different immigration rules applying to different parts of what is the same state, there are examples from elsewhere, including Canada, that the Scottish Government has been relying on as part of its political campaign to try to get a different system in that part of the UK. But that is all to play for.
I mean, what I found interesting about this, Christine, when I was talking to clients about this, is there are a number of businesses in the UK that rely quite heavily on sort of seasonal European workers. You know, your workers from Poland or Eastern Europe willing to sort of accept perhaps lower wages than UK citizens to do certain tasks, and they quite literally ship them across. They carry out the work for 3 months and then they go back, and that whole process I think is going to become a lot more challenging for businesses. The other thing also I think we were talking about is if you are thinking of moving, for example, a management team that might be located, for example, in France, and you're thinking, oh, I'll do that at the start of 2021, I'll move them across, I'll base them out of the UK, you might want to actually accelerate that, because during 2020 they'll be able to establish the residency point I think you were picking up earlier. And I think the third implication, which is particularly interesting again when you're looking at like technology businesses. And here I think the analogy is quite similar to the US. It was interesting observing, I think, in the US that there was a number of sort of Indian nationals leading the large, technology companies in the US, from, Microsoft and so forth. That actually, if the UK is also taking more of a technology focus, it's going to make it potentially easier to have people with those skills and to attract that sort of rest of the world talent to the UK, enable them to come in. But again, I mean, it's going to be an interesting dynamic, I think, as we see over the years develop.
And there is some expectation, of course, that the right to work for the citizens of any given country will play into free trade negotiations on a bilateral basis, whether that's with India or with China or with other countries, that the right to have national workers move more freely within the UK might form part of that, and is going to be a political challenge for the government to manage that tension, with migration having been so high on the agenda.
Yeah, and one of the interesting facts is if you actually have a look at the migration statistics on this, and because this has been such a hot topic, I think, around the whole concept behind Brexit, which is the idea of sort of controlling the borders, is we've seen sort of people moving from the EU sort of fall off a cliff. Effectively, that's gone down substantially. But interestingly, it's been almost compensated by people migrating then from the rest of the world, because businesses fundamentally still need the talent, still need the people. And that's probably one of the biggest challenges for the UK economy is, can I get the people to do the work here in the UK? Can I continue to attract the right talent? And that would be even at the lower end, from fruit picking to, I don't know, Scottish distilleries, for example, rely heavily on sort of seasonal workers, but right through up to sort of IT experts, to senior management, and so forth. If you are, for example, a US-based companies used to sending people around the world, actually, there's probably good news in a sense, in that you already know the process. You're likely to have a sort of sophisticated sort of HR team that deals with it. I think where it gets more challenging is for your sort of small and medium businesses who might want to locate people and are going to need the experts to support and allow the time and factor in the cost of doing this, whereas before you might have just sort of sourced EU nationals to keep it simple. So I get to tackle the wonderful question of what happens to the ability to share data, and I think this one has been a topic that has been very much on the agenda of lots of businesses, not the least of which because a number of sort of UK, European, and to extent businesses in the US and the rest of the world have sort of suffered through the rollout of GDPR and all the sort of compliance and regulatory sort of activities that flow from that. And so having sort of finally bedded that down and got themselves comfortable, here we are with Brexit and the possibility that certainly in terms of how the data flows to the UK, all of that could be sort of torn up, and here we go having to start again. The good news is we don't think that's going to be the case. So certainly this year, the positive about it is because of the transition period, broadly, everything stays the same. So if you have in places compliant regimes under GDPR for the transfer of data, both to the EEA and the EU and to the rest of the world, that still fundamentally works. What is, however, interesting is what happens afterwards. So one of the things that the UK is heavily reliant on is getting what's called an adequacy decision from the EU. And effectively what that means is that the EU says, we've had a look at you, the UK, we've looked at your data protection regime, and we think that doesn't have to be the same, but it's sufficient enough, it's comparable enough in terms of the way you protect data, that we regard you as adequate, and we will effectively treat you in the same way as we will treat other EU member states and how we allow data to transfer. What is quite interesting about this is there are only 13 countries that have actually achieved an adequacy decision, and some countries that you might expect are, would have a sort of adequacy policy actually don't have that. So, countries of similar regimes, background, places like Australia don't yet have a sort of adequacy decision. You would think that with the UK having basically followed GDPR and implemented it, that an adequacy decision should be pretty much a formality. But again, with that political backdrop, it could well be part of a trade negotiation. Is it a chip they hold to ransom? Is there worry about divergence? And even if you get an adequacy decision, that can be revoked in the future. So there are some factors that need to be sort of thought about when you're moving data. And all of this, of course, is rather complicated because let's face it, we don't live in sort of isolated countries anymore, and certainly with the way we do business, we live in a sort of data-driven, interconnected world. And probably sitting in all of our pockets, we'll have a Android or an iPhone or something of that nature. It's got loads of data on it. That data is being flipped into cloud servers across the globe, and it's being accessed by global companies. And how is all of that going to work? And again, this is against a backdrop of sort of GDPR was the start of it, but we are seeing a general trend, I think, across the world about wanting to have sort of greater accountability to how you use data, greater control for people over the use of their data. And certainly, again, our friends in the US will be aware of like the Californian Consumer Privacy Act, which again, while it takes a different approach to GDPR, generally is concerned with these sort of issues. And we're seeing similar approaches, I think, coming in places like Brazil, India, New Zealand, all of these things that need to be borne in mind. So where does that all leave us? Well, as I said, the good news is 2020, pretty much we're okay, but that doesn't mean you should sit on your hands, because what is going to happen after 2021 is still anybody's guess. If we do get the adequacy decision, then that is extremely helpful in the transfers between the UK and the EEA. And the EEA, in case you're not aware, is slightly different to the EU in that it takes the EU countries plus you add Norway, Liechtenstein, Iceland, and Switzerland's not strictly under the EEA, but they have a sort of similar treaty arrangement. So it's a slightly wider, but broadly encompasses most of the European countries. If we don't get the adequacy decision, then of course it gets slightly more choppy in that effectively not only would the EU not recognise the UK as adequate, but the UK wouldn't recognise the EU as adequate, would all look rather petty, but actually would mean that you would need to do a lot more paperwork and think about how you're transferring data. And that can be particularly relevant if you've got a sort of integrated sort of data transfer between your EU operations. Moving forward, if you're transferring data from the UK to outside of the EEA, so for example, you're transferring it to the USA or to South America or Africa, then what you would have to look at firstly is a similar approach that's currently adopted, which is, are you transferring it to a jurisdiction that has an adequacy decision? The expectation is the UK will basically accept that the current 13 countries that are deemed adequate will continue to be adequate, because there's no real reason why they shouldn't be. To countries that are not adequate, you would then have to look at the UK regime. What the UK is effectively doing is in essence sort of importing GDPR into its domestic legislation, which it's already done and plan to continue to do with that. So you'd be looking at the same things that you have to do currently, but you would have to do it with a sort of UK specific compliance in mind. So you would need, for example, standard contract clauses. If you're transferring data, in the case of transfers to the US, you would look at sort of privacy shield and so on. So fundamentally, the good news is that your approach to data transfers from the UK to the rest of the world remains substantially the same as it does currently under GDPR. What will get more interesting, I think, is what happens going forward. Is there an appetite for the UK government to try to be sort of more business friendly, perhaps to look at what other jurisdictions in the world are doing in terms of how data is protected and adopt that rather than sort of European approach? And therefore, we would sort of recommend a number of practical steps are taken. And the first and obvious one is this position needs to be monitored. Like, you don't necessarily need to do anything radical at the moment, but certainly throughout 2020, we need to see where the wind is blowing. And post 2020, you'll need to sort of keep it under review to see what happens with the UK government. In order to achieve that, what we would recommend firstly is that businesses that are transferring data to the UK, outside the UK, whether to the EU or sort of outside the EU, do a sort of data mapping exercise. And that is, you understand where the data is flowing. You'd be surprised the number of companies that don't actually understand where their data is moving, which is sort of the starting point for a sort of disastrous data protection issue, effectively. Once you've got that data mapping, it then becomes a lot more easier then to follow what you need to have in place. What you'll likely need to do is to keep your privacy documentation under review. So things like privacy notices, what you're saying in your contracts in terms of data processing agreements, what your internal policies are about where you store data, how you store data, particularly relevant if you're storing data on cloud-based servers. So for example, you may have a cloud contract under which you've sort of agreed with the cloud provider that your data can be stored in any server based within the EEA. Depending on what might happen with the UK rules, that might need to be revisited to say, well, hang on, that may not work. So things that are sort of aren't obvious could well come up. And I think not in the short term, but certainly in the long term, this is something that people will need to be mindful about. The good news, I would say, from a UK regulatory perspective is any changes that do happen, we would anticipate being telegraphed well in advance. I don't think the UK wants to be seen as sort of trying to be punitive or catching companies out simply as a result of the consequences of Brexit. So what we would expect is changes to be telegraphed, a grace period to implement it, a focus initially on compliance, and then finally, after having sort of given people a chance to adapt, if they don't, then you would look at enforcement action. And that's a similar pattern that we've seen to how they've approached GDPR. And there's really no reason why future changes they wouldn't take a similar approach going forward.
And I think that certainly from my perspective, the notion that the UK would not get an adequacy decision that for me is a very low risk. But one of the issues that it raises is an issue that is raised around the negotiation generally between the EU and the UK, and that's about adjudication and the EU's continued wish to see these kinds of arrangements governed by the European Court of Justice. And that's going to prove to be a political sticking point when it comes to negotiations more generally, the extent to which the UK will be prepared to accept any role for the European Court in adjudicating on these arrangements. But we will see how that turns out.
So in addition to the transfer of data, obviously the thing that's grabbing the headlines at the moment is what happens if I supply goods to the UK or I buy goods from the UK. And this is particularly relevant when you think about global supply chains. And the classic example of that being the automotive industry, which is very much about sort of just-in-time manufacturing, products crossing border back and forth, sort of crisscrossing depending on where particular elements of the manufacturing process are taking place. If you do supply goods to the UK, whether from an EU country or from outside the EU country, or you're buying goods from the UK, the key issues that are sort of being driven by Brexit are effectively around, firstly, the impact of tariffs, and secondly, and customs procedure generally, and secondly, regulatory compliance requirements going forward, plus potential changes to regulation. Now, you might say, well, hang on, I'm already outside the EU, I supply into the UK, shouldn't it just be business as usual for me? And the answer is, well, both yes and no. And the no comes from the fact that one of the things that's been highly talked about is if a deal is not struck where they minimize the tariffs between, or eliminate even the tariffs between the UK and the EU, one of the things that the UK is not very well set up to do is actually to customs clear all of the current trade that happens between the UK and the EU countries. So fundamentally, they don't have the customs office, the IT facility, or even the land space at sort of UK ports to deal with the volume of goods that is crossing the border. And there's been lots of talk about whether we would have, for example, large queues backing up from the port of Dover, whether even if you added sort of, a couple of minutes to each clearance of goods passing the border, whether that would actually compound out to like days and days of delay. Now, some of this might be argued to be scaremongering. I think certainly from a UK government perspective, it's not in their interest to have these sort of things happen, but equally they're challenged by the fact that if they don't do a deal with the EU, neither will the EU want to be seeing them as sort of effectively just a sort of wild west of sort of product regulation or products moving across the border. Practically, what the government has been advising anyone who is exporting or importing is they should register for something called an EORI, which is an Economic Operators Registration Identification Number. And the idea is that number is going to help facilitate cross-border movement. There's been lots of talk about sort of technology solutions, minimizing time at the border. But I think there is some sort of, you need to be slightly wary of what they will actually be able to achieve or deliver. I think in practicality, they will do some sort of deal with the EU, but I suspect it may not be comprehensive, and we could have a real mixed bag of some things being sort of tariff-free and others not. Certainly when I'm talking to companies within the UK, there's a lot more talk about use of bonded warehouses, so you're not clearing goods at the border. It's able to go straight through and sit in a bonded warehouse. And there's been lots of speculation as to whether they would sort of increase the sort of free port concept, whereby, for example, if you're importing from Asia, you can bring your goods, clear it into a free port in the UK, or potentially one of the few free ports in Europe, and then that's where you would sort of cross-dock it, break it up, and send it to its relative destination. So part of the shipment remaining in the UK and the rest perhaps heading on to Europe or vice versa. But all of these things mean that what you have to do is actually have a look at your supply chain and say, does this still work in light of what the deal is happening, and where does sort of UK companies and products fit into that? There has also been a lot of speculation about some existing UK manufacturers who were historic exporters sort of refocusing on a domestic market. And the example that sort of hit the headlines has been about a sort of large Nissan plant based in Sunderland, of which 80% of its capacity is actually exported to the UK. So it builds cars and it ships them out to the EU. 80% goes to the EU, 20% to the UK domestic market. And there's been speculation as to whether Nissan would be trying to use this as an opportunity, for example, to corner the UK market. Basically, it would have a competitive advantage if tariffs are imposed. Its cars would be cheaper, and could it substantially, and we're talking about increasing its market share by 5 times, effectively redirect all of that production just into a sort of UK domestic market. Now, it's an interesting idea. I think practically it's going to be challenging for someone to completely restructure a sort of export to a domestic market business, but we certainly, I think, are going to see companies looking at saying, should more of my production be remaining in the UK? Are there markets outside the UK? But again, geography, I think, plays against the sort of larger shipments, where smaller things may be more amenable to that sort of refocusing. So it's going to be an interesting dynamic as I think companies look to restructure their supply chains. And inevitably, supply chain restructuring doesn't happen overnight. It happens over a number of years. The other thing also that will happen if you're buying or selling goods is thinking about how regulation impacts on that. Some very tangible examples are going to be things like CE marking. If you sell to the EU, you'll be familiar with the idea that your product needs to be CE marked, and the fact that once it's CE marked by a authorized assessor in one EU country, you can then place that product all onto the European Union market. In this case, you'll end up again with a sort of parallel regime where you will also need to be effectively having it marked for the news, what's called the UK conformity assessed marketing, or the UK CA or CE as it'll be going forward. You'll also need to be thinking about the labeling of your products, particularly if there's divergence in terms of how products might need to be labeled. You're going to need to think about who is the person putting the product onto the EU market. Historically, it might have been a UK-based entity, but you may require someone in the EU, and it's likely to be the person who first receive it, who's going to be regarded as the importer. And this is important because then they're liable for that product. They're liable for its regulatory compliance. And there's also going to be questions, I think, sort of practically about, can I manufacture one homogeneous product to supply across the EU? And there's going to be interesting decisions as sort of the EU approach potentially diverges from the UK approach. And you may have seen the headlines about a sort of EU parliamentary decision about looking to require a single charging cable. So the idea that Apple's Lightning cable suddenly wouldn't be permitted within the EU and rather moving to USB-C. I mean, all of these are going to have impact as to how you make your product, particularly if the UK says, well, actually, we're not too bothered about that, but the EU is driving a sort of different solution. Practically, things to think about: look at your contracts, things like your definition of territory. You might talk about the European Union. You may need to amend that to ensure it covers the UK. References to EU law may now need references to UK law. The situation is still fluid. You might want to think about exit rights. One of the heads up is the UK, and certainly if you're using English law, and I'm fairly sure, Christine will correct me if I'm wrong, but Scottish law is the same, doesn't really have a concept of sort of an economic adverse event, just simply because things have changed doesn't entitle you to unwind your deal. There's no sort of economic hardship relief. Therefore, you need to build it into your contracts, either through a specific definition of force majeure, through regulatory change, or a MAC clause, a material adverse change clause, or some other mechanic that will enable us to deal with things such as sort of cost increases due to changes in tariffs or taxes or customs burden or currency movement, or the like.
And so I'm going to round off the 9 substantive questions with whether the UK is still the jurisdiction of choice for my international contracts. And we certainly hope it has been the jurisdiction of choice for your international contracts. And of course, the positive reasons for choosing English or Scots law as the law of your contract, and choosing the particularly English courts for many of you as the courts of choice for your contracts. Those reasons will persist in broad terms whether or not the UK is formally a member of the European Union. Indeed, for many of those contracting under English law and choosing the English courts, the EU is not the factor that has led them in that direction. They may be contracting parties from many other parts of the world rather than EU member states, and we don't expect that to change. And we have seen the UK government, the United Kingdom Ministry of Justice and the law societies in the UK working very hard to promote the continued use of English, Scots, British law and the British courts as a forum for disputes. All of that being said, we again in the UK will lose the benefit of our accession to various agreements on jurisdiction and enforcement of judgments, because we have taken the benefit of those through our EU membership. The UK has already taken steps to accede in its own right to the Hague Convention on choice of court agreements and on choice of law. So we don't expect things to change in the short term, and we still expect the courts in the UK and indeed in the rest of the EU to respect choice of law clauses. So as matters stand, that's again something that is relatively low on my risk register for clients who are worried about the impact of Brexit. And I think, conscious of the time and of the desire to have questions, if there are any, Nicole, I will stop there on question 9, and if we move on to question 10, we can talk about some other things you might need to think about with Brexit that haven't made it to the headlines so far. But Nicole, do we have questions?
There are not any questions at this time, but it's a reminder to anybody participating, if you do have a question, please feel free to submit it using the question module on your webinar dashboard, and I will see to it that it gets to the presenters.
Thank you very much.
So perhaps while, if you're thinking of having any questions, and I appreciate Brexit's a fairly sort of meaty topic and one that certainly Christine and I are sort of living and breathing, perhaps more so than our audience members sort of immediately. But I mean, lots of things hit the headlines. The headlines tend to be very political. What's interesting is the ripple effect, I think, that's going to happen as these changes take place. So, for example, there's been a lot of talk in the press about what happens in terms of the movement of goods and the movement of people. There's been some speculation as to what the impact has on the services industries in the UK, and the UK is a big service exporter. And there are ones that have hit the headlines, such as regulated industries, such as finance, banks, insurance companies, all which fundamentally have actually sort of Brexit-proofed their business. They've done the restructuring, they've created the entities. Quite a lot of them have been thinking about this now already for the past 3 years. But services such as technology services, legal services, interestingly, all of these things have sort of been largely ignored. And the expectation is they're also going to be largely ignored when it comes to a sort of free trade deal, just because it's too complicated, and you don't tend to see these in trade agreements. The other things that are coming up, which again don't hit the headlines, are about what do you do about your IP registration. Certainly the recommendation is you ensure you maintain a sort of dual approach with UK and EU registrations. If historically you had a sort of EU-wide trademark, you'd want to back that up with a specific UK trademark. There's going to be some interesting questions about the impact of parallel importation rules. So at the moment, the way it works is you cannot use your IP rights, for example, to stop importation of products that have been initially sort of imported into another EU country. So, for example, if you supply products into Poland at a particular price, there's nothing to stop that product actually moving within the EU to another country, for example, the UK. Going forward, what is interesting is it looks like the UK wants to take a position where you can't stop if a product's been placed in the EU. They're then free to import in the UK, and you can't use your IP rights to stop that. But interestingly, it doesn't look like at the moment the EU has adopted a sort of similar position. So you could have an interesting scenario in the future where if products were first placed on the UK market, you can stop them then being effectively exported into an EU market. As long as the UK sort of remains a sort of higher price jurisdiction, that may be less relevant, but it's certainly a dynamic that certainly for certain industries could get quite interesting. You may have sort of been asked about the European digital single market. Comes up quite often. For those of you who don't know, the idea behind that is an EU initiative to increase online access to products and services within the EU. The idea being, no matter where you are in the EU, you can effectively purchase through a sort of online medium products and services from businesses in other EU countries. The UK is obviously no longer having a say in how that might work, wouldn't strictly be part of it. And to a certain extent had a sort of very different attitude to a lot of the EU countries on how that should work. So it may sort of encourage the EU down a path that it may not have gone down before, and particularly with things like the approach to sort of social and digital media marketing. And that could have a sort of global impact if you're, depending on how you're sort of marketing through, you know, Instagram or Google AdWords or things like that. Perhaps just as we finish up and see if there are any questions, I think the one observation I would have with Brexit is there is a massive amount of speculation as to what is going to happen. And to be perfectly frank, not a lot of substance just today. So there's a lot of posturing, there's a lot of sort of wish lists, but there's not a lot of actually knowing how it will pan out. And certainly if I took my crystal ball back to sort of 2016 and tried to predict would we be here today, I can admit that I would have got it very wrong. So I think the best advice we can have is certainly if you are going to do business in the UK, it's still open for business, but keep everything under review. And similarly, you're going to need to look at sort of the direction of travel of the EU going forward without a sort of UK voice in the mix as well.
So we do have a couple questions. The first one is, what do you think will happen with the value of the pound? If
only I'd kept up with my sort of study in economics, I think at university.
I think, Nicole, we have. I think most of us think that that the market has already factored in quite a lot of the Brexit effect already, and therefore we would hope not to see some of the volatility that we have seen over the last 3 years. And I think one of the things that will perhaps prevent that same volatility is that I expect there to be fewer political events, if I can put it like that. We have spent the last particularly year and a half with a large number of crises or perceived crises in the political process in the UK. We have a much more stable political environment, not the political environment everyone wanted, but it's a much more stable political environment in which we're not expecting to see the kind of political volatility we've seen, which has had a knock-on effect on the currency. So certainly for my part, again, not professing to be an economics expert, I would expect to see a degree of greater stability, at least until near the end of the year, when we're coming up to that deadline again for a deal to have been reached with the EU.
You know, and I think that's exactly right. I mean, if you look at the currency volatility, I mean, what was interesting was the Prime Minister came out on Monday, I think we noted earlier, and said he didn't want regulatory alignment, and immediately you'd seen the currency drop. Whereas prior to that, even in the lead up to Brexit, you'd actually seen the pound strengthening. So I think what that says to me is there's a lot of faith sort of globally that actually the UK has a strong economy, and the biggest sort of headwind is what's going to happen with these Brexit negotiations. But if that gets resolved, I think you could see the pound strengthening quite rapidly. The flip side is, as Christine's pointed out, is that 31st of December date, which is effectively back in no deal territory. And if we thought there was going to be no deal, I think again you could see the pound fall off a bit of a cliff again. So there is an element of volatility, but I do agree with you that once the posturing gets out of the way and they get down to sort of brass tacks, hopefully what we'd see is much more sort of stability and less sort of up and down as we go.
And we have one more question. What are your expectations regarding employee rights? Do you expect any changes to legislation affecting those?
Not in the short term. I've spoken to a number of HR professionals who were very disturbed to see that the UK Parliament had removed what had been put into the Brexit legislation last year, which was a guarantee of meeting EU employment law standards. That has been removed from the current legislation, but that does not mean that the UK government has got plans afoot to change the regime on employee protections. I think it was a political move simply to give the government greater flexibility going forward, but my own view is that the UK government and Parliament have got quite enough to deal with at the moment without embarking on wholesale changes to labour rights. If that is something that is going to come, it's liable to come in the medium to long rather than the short term.
Yeah, I mean, from my perspective, what I always thought it interesting, even historically, about employment rights is if you've done transactions in the UK and Europe, you've probably come across something called TUPE, which is a EU regulation about the transfer of undertakings and the protection of employees, which basically says if you do a sort of outsourcing or you sell a business, the employees go with that business. So you can't just, unlike the US, where you would leave the employees behind and you could quite easily sort of hire and fire. Actually, the employees have that protection of moving with the business, which is both helpful and unhelpful depending on the situation. What was interesting about that was the EU came up with this regulation, and actually when the UK implemented it, they effectively gold-plated it. It's one of the more sort of onerous regulations, even compared to countries that you might not think you might think would take a more onerous position, haven't taken the same as the UK in the way that works. And what we might see is in that sort of type of regulation an unwinding of it. And I think that might come if we see a UK government that becomes much more susceptible to perhaps a sort of US-style lobbying by particular industries. Certainly we haven't seen that to date. I think lobbying is certainly not done in that sort of US focus. But who's to say in the next 5 years we couldn't see a sort of different attitude. So I agree with you, Christine. Short term, I think it's pretty much business as usual. Medium term, long term, very much harder to tell. So.
Well, with that, Christine and Paul, I want to thank you so much for your time and your insights today. I want to thank all of our participants for listening in and joining us, and we thank you. And this recording will be available for your colleagues in the coming days or for those who were unable to attend. So thank you very much and have a wonderful day. Bye-bye.